All right, good morning, everyone. We're going to get started very shortly. Today's training is going to be going over identification and notification of claims. Kai's going to be presenting, so I'll hand it off to Kai.
Okay, good morning. This is going to be a little different, so we'll see how it goes. It's been a while since we talked about change orders, and I know in the construction committee, I'm not sure if Kaha'a's here, but we've talked a lot about claims, and so there are quite a few definitions we're going to go through today. And again, identifying what a change is and notification of a claim. This is actually going to be roughly one of 9 in a series. So today we'll go, and I'm not going to read all this because we do have a lot of slides. So, but this is what's coming. Identification of claims, going through differing site conditions, interpretation, what is acceleration and mitigation of project delay, delays and time extensions. We're going to piggyback a little bit off of schedule analysis that Joel did, documentation, best practices to support claims, CPM schedule review and analysis, probably pulling together what Joel has gone through in the past, loss of productivity claims. So that has to do with efficiency. A lot of times you'll hear contractors say, you've been, because of delays or changes or differing site, or maybe it's design issues, there's been a loss of productivity. So we're going to go through that. And just in general, pricing, construction changes. That's the outline. We'll see how it goes, and we'll talk about notification and waivers and some just doctrine in general. So again, lots of definitions. Okay, so what is a change? What is the law? What does the spec say? So wanted to make sure everybody understood, not only does our spec define what changes are, it's actually part of Hawaii's law. So 103D 703 talks about the claim shall be written in writing and state the facts surrounding the controversy. The claim shall be submitted within the time specified in the contract. So I'm going to have Cord monitor the chat for me because I'm going to ask you guys questions. So does our contract define the terms? Notification, do we have the time specified? So let me know if you know what that time is, because we're going to go through in a minute. Modification of contracts. Public contracts may be modified to reflect necessary change in plans, specs, and the requirements of the contract, provided such changes are within the original scope and modification is in writing. So lots of writing. Okay, real quick, what does our spec say? Do we have durations? Just say yes or no, because I don't see anything going on in the chat now, and I know it's a little bit early, but this is going to be a little interactive. Who's on? Who's on that I can call on? Oh, Calvin. Because of alphabetical, you're like one of the first that show up. Okay, so what is a change or claim in our contract? We're going to go through a lot that's in the spec. So changes of work may be accomplished after execution of the contract without invalidating the contract by unilateral, bilateral changes. Changes shall be within the general scope and include additions, deletions, and other revisions. A claim is a written request for the contractor to add for additional compensation, time, dispute resolution regarding interpretation of the performance of contract. To be valid, the contractor must submit timely written notification, typically within 30 days. Failure to comply with notification results in the waiver of a claim. So right now, within either best practices or the spec, how long do people have to put in, let's say for minor changes, their notification? Do you guys know? Open up one of 402 so you can follow along. So what does it say? I don't know if I'm gonna like a really quiet morning, so you guys are gonna have to pipe in. Anyone? Okay, it's still early. Not one person in the chat. Very disappointing. Okay, I'm gonna move on.
30
So,
days.
yes. Well, we're gonna go through that. Minor changes. So go to 104 because we're gonna break this down. Because this is all about identifying a change and notifications. So under 104.02, that's where you're gonna find the majority of this. The engineer may direct minor changes in work with no changes in contract price or time of performance. So the contractor believes a minor change directive justifies an increase of contract time or price. It must follow oral and written notification requirements as set forth in O2B orders and directives. So 104 has various requirements for notification. Okay. And we're going to go through some legal terms associated with that. But the first one is minor directives. There's actually information on differing site conditions, but we'll cover that when we talk about differing site conditions. Okay, so what does it say? There's a lot of words on here, but I kind of wanted to break it down so you saw what is in there and why is this all important? Why do we want to pay attention? So this is a little bit of a soapbox because notifications are required or precedent or condition to claims, payment, yada, yada. And I know sometimes, let me get rid of this thing. Sometimes people don't follow the contract. And so this soapbox is about why we should follow the contract, why it's important to have those notifications, and why the entire state needs to do this consistently. Otherwise, it's to the detriment of everyone, our consultants, our districts, everything. So this is a soapbox. Here we go. This is what it says under minor order and directives. So this is the beginning of it, except for minor changes referred to in section A, which that kind of talks about whether, you know, a change that does not affect time and does not affect price. So those are minor directives. Subsection A above, only a duly issued change order or field order may alter the contract and work requirements. So it's like step by step. And I highlighted in red the important pieces pertinent to our discussion today. So any order, directive, instruction, interpretation, or determination from the engineer or any other person that is not a field order or change order may be considered as a compensable change only if the contractor gives the engineer an oral notice no later than noon the following workday. So that is one requirement in order for it to be a compensable change and for the contractor to seek compensation. It is precedent, it is a condition, it is required. Working day of its intent to treat such order, direction, instruction, interpretation, and determination as a change directive. So number one, contractor has to provide oral notice by noon the following working day. And I don't know how many construction engineers we have on, but this is important, not just for your district, for the entire state. And so the construction engineers really have a responsibility to make sure that your staff, your consultants, everybody within your district is following these things. So we're going to talk about why. Such notice must be given before the contractor acts in conformity with the order, direction, instruction, interpretation, or determination. So that means they can't go and do it and then tell you. They have to, one, after they're given a directive, tell you verbally it's that they consider it a change, and it has to be before they do the work. So now we have two conditions. The oral notice shall be followed by written notice of potential claim that must be delivered to the engineer within 5 days after communication of the order, direction, instruction, interpretation, determination of the contractor. So now we have oral by noon, before the work is done, and within 5 days, you must have a written notification. Though now, what does the written notification have to have? Not optional, have to have. The written notification of potential claim shall state the date, the circumstances, the source. So at a meeting, if you told somebody to do it, if you gave them a letter, you wrote something to them, was it instruction, interpretation, determination that the contractor regards it as a compensable delay, means they should get money for it, and provide a detailed justification for additional payment or time. So all of these details become a condition for which they must perform these notification requirements, or they waive their right to compensation. That means they don't get it. That means in accordance with the contract, we don't have to pay them. That means if we go to court, we're going to win. Now, we'll talk about court because we don't go to court a lot, but all of these little red points, if we follow these things and the contractor does not follow these things, if we go back, way back to training that we did 5 or 6 years ago, golden rule, right? We want to treat people fairly, but at the same time, these are important because we don't want to get to the end of the project and have things come up. And when we entertain those things at the end of the project, or we entertain those things without following this, we start waiving our rights under the contract. So that's what my soapbox is today. Let's all not waive those requirements. As we get better and better at doing that, then we can actually just reject it. And they waive their right, and we have legal precedent or doctrine that supports us. And if we want to go to court and we want to hold our ground, we'll win. Such written notice may not be waived. So that's another legal term we're going to talk about, and shall be a condition, again, legal terms, precedent, legal term, to filing any claim by the contractor. So as long as we are all consistent across the state and everybody makes their contractor do all these red points, and if they fail to do it, they waive their right and they will not be able to claim. So I don't know if this has ever really been, especially with DOT, and I would love to hear feedback if you guys know this, but this is all really, we have to do it statewide in order for it to stick in court, let's say. Again, next sentence, and I started summarizing this because it didn't fit in the slide, but shall not be treated as a change for which the contractor may make a claim for an increase in contract time, compensation, or price related to such work. They have to file a written claim with the engineer within 30 days. So again, notification, oral, noon. Notification, 5 days in writing. When we deny it, if they have not provided these red items, we deny the claim because they have waived their right, they haven't provided proper notification, that's all your justification. Then they will not be able to claim. They will not be able to go through 107 because they have not done these things. They would lose that battle in court. Again, super important that everybody across the state is doing it because that would be their defense, and that would be their only defense. File a written claim with the contractor within 30 days after delivery to the engineer. Contractor's written notice of potential claim. Failure by the contractor to submit written notification of potential claim waives all rights. Okay, so we're going through a lot of definitions, but I wanted to start with the identification of a claim, and we're going to talk a lot about notifications. So this is orders and directives. There's another section. And these two were kind of the same, so we're going to dissect this a little bit. So again, 03 talks about field orders. So what does it say? Upon receipt of the field order, the contractor shall proceed with the work as changed by the field order without delay. So that means if we give them a field order, they have to do it, period. And if they disagree, not doing is not their option. What is their recourse is notification and then follow up with a claim. And there's a process. The process had deadlines. As long as we adhere to those deadlines, we as DOT do not waive our right in a contract to reject. We don't waive our right as long as they're providing notification and we all follow the process. So again, what is the process? If the contractor does not agree with any terms, conditions, or adjustments to the contract price, contract time, or both, the contractor shall file written notification of potential claim with the engineer no later than 3 days of receipt. So these sections are all a little bit different, and differing site is actually a little bit different. So super important. I was actually thinking as we were putting this together that we should maybe do an infographic that shows you what the different things are. So you have a snapshot that really emphasizes these durations.
Is that 3 calendar days or working days?
That's a good question. I'd have to look at the terms because it's usually working day. I think there's a definition in 101 that says something like if it doesn't say it's default working days, but that's a good question.
And I guess that's true for all, I guess the same question for all the
right.
notification
But
times.
that's interesting. And maybe this is something that needs to be cleaned up because the next section does say working days. So let's follow up and make sure we understand. And that's why I think an infographic would be really good. Okay, so no more than 10 working days after the receipt of the written notice of potential claim from the contractor, a written response shall be issued for the subject work if the state agrees that it constitutes a change. So again, they're going to put in notice. If you think it's a change, you should respond. And again, part of this is notice is not meeting minutes. Notice is not, well, it could be emails, and it should be a formal notification. And we're going to talk about, again, what should be in there was in the previous section. The contractor shall deem it a rejection of potential claim if written response is not issued within the 10 days. So our inaction, the default will be it's rejected. So the contractor still has to follow these requirements. Our contract is written in our favor. So if for some reason we don't respond, the contractor is supposed to take that as rejection, and they're supposed to, again, file a written claim with the engineer within 30 days delivery of the notification. So it's so important for us to track these durations. The contractor shall deem it a rejection of potential claims. So now they wrote a letter, maybe we didn't respond, so they're supposed to take that as rejection. Now, again, super important that everybody across the state is doing this because that's going to be our waiver. If we don't do it, then that's waiving our right under the contract. Okay, so if they give us a notification, we don't respond, it's supposed to be rejected. So we say, no, it's not a change, it's rejected. Then they have to put in the potential claim within 30 days. So that's another notification within 30 days. Then we start going to 107 where they have to make sure they have XYZ. I honestly didn't go through that, but that's another thing maybe in the infographic. Because again, under the claims, under 106, there are requirements. After field orders in our contracts, it goes into change orders, again, notifications. I wanted to start with that to really break down what is in our contract, because a lot of the terms we're going to talk about next are precedent, condition, prejudice. Why do we have to have all these things? Okay, so we're going to go into...
One second.
Yes.
1 second, sorry. So in the chat, thank you, Chan, and thank you, Andy. They specified that definition says no designation of calendar or working day. It shall mean calendar day.
Thank you. Yep. I knew it was in there somewhere. Great question. Remind me, Cord, let's add it in here to make sure that's clear. Okay, so the most common change is a bilateral change. Not going to spend a whole lot of time on this because I honestly am not sure how this whole how long this presentation is going to take. So I'm going to leave this, but basically you and the contractor agree, you both change, or you both sign the change order. The benefits is it's very clear. We have better cost control because we're agreeing, but again, we have these durations in the contract, so we have to kind of track it, move quickly. Otherwise, we should agree to an extension in writing, and we'll talk about that in a little bit. So I'm not going to spend time on this. Most people understand this. Come on. All right. Now we have unilateral. And I know this is scary. Scary, scary, scary. I personally love unilaterals, so I'm going to tell you why. Unilateral change order is a written directive issued by the owner, such as DOT, to modify the scope, method without prior agreement on cost or time, without the contractor's signature or concurrence. It's authorized under most contracts in our situation 106 104.066 of the specs requires a contractor to proceed with the change, even though price and time adjustments may be determined later. Okay, so why do I like this? I like it for the number one reason that it keeps the project moving, that work can proceed without waiting on pricing negotiations. And unfortunately, I feel like a lot of times, and I don't know if it's because we usually waive our notification or we waive these kind of requirements, but it takes forever for my contractors to give us a price proposal. And so if we wait for them, we start to waive our rights under the contract. So if they're not going to be able to meet these timelines, you want to extend it in writing. Say, okay, you didn't meet this, but if you agree and you acknowledge, let's make sure they're doing everything in writing, that they're following the notifications that we just had. And again, differing site is they have a little bit different notification requirements. It prevents the delays due to the paperwork or disagreement. So again, we can move forward, give them time, but the rest of the reasons is why I like it. It allows for payment, even if the contractor hasn't given us the cost proposal yet and agreement can't be made. So at least if they're proceeding with work, we can pay them. So I know there's this anti-unilateral, both sides, but if the contractor isn't meeting their requirements, it's super important that we don't waive our rights under the contract. So we have to do something. We either have to get things in writing. If we're not getting in writing, we have to do unilateral. We have to do something. Inaction starts to waive our rights and is a detriment to the entire state. Now, protect the owner's position. It establishes a clear written record that the owner directed the change, that we ensures cost control. The contractor must submit the cost proposal and is limited to actual costs. We start to forego a pre-priced change because the work is already happening. And I don't know if Kaha was on, but at one point, it was probably 5 years ago, when we were talking about changes, if the change was not pre-priced and the work proceeded, then it should be basically following force account, that we should be pricing the work as it's actually occurring. And we're going to talk a little bit about that. It preserves our right. We can always audit. And again, I don't think we've ever done this, but there is a cost to an audit. I would say roughly between 10 and 20,000, but depending on the size of your change, it might be better to do an audit than to settle. I know some of the changes that we're involved with, Joel's on there, we're in the millions of dollars. And if we can't agree, then we could just audit your books and kind of see what your costs were. So that's a way to settle things. Do a unilateral, audit the project files and figure out exactly what the costs were. I've never done that with DOT. I know we've done it. I did it a little bit at heart, but never an official audit. But that is recourse that we would have. It limits the contractor delay claims. If the contractor refuses to proceed without agreement, the unilateral change provides as a basis to argue that lack of cooperation or failure to mitigate on the contractor's part. So again, and For complex changes, it might be better to do an extension, but again, we want all of this in writing to make sure we don't waive our rights under the contract. It shifts, and this is the other reason I like it. It shifts the burden of proof to the contractor. If they're not able to give us a change, and I know, I don't know if Ben Gardy's on, but we did this a lot at Makaha because the contract and the changes were so complex. We had to get a unilateral out because contractor was taking forever to get our proposals, and we kept asking, wouldn't get it. So in order to proceed, we had to issue something, and it gave them time to come back with actual costs on how to settle the disagreement. Okay. So this brings me into that what if the contractor doesn't give us a change proposal? How do we deal with the costs? So this is one of the big issues that I have with unilaterals is now the contractor comes back and says, here's all my costs associated with this work. So the analysis we have to do, because one, if it's after the fact, it should be actual costs. But a lot of times there's actual costs that are all their inefficiencies, yada yada broke down. So how do you differentiate between actual costs plus reasonable inefficiencies versus contractors inefficient, they don't know how to do this, and they'll come back and say, well, these are our actual costs. Okay, but we're not obligated to pay your inefficiencies over here. So a reasonable inefficiency cost is one that is clearly caused by the change, falls within documented productivity losses, and is justified with data. So we don't have to pay them for every cost they incurred. If they weren't running their business well, that's not our obligation. So we can cap those costs. Right now, on Makaha, like I said, I don't know if Ben is here. That's one of the where we're stuck right now because they had to, they couldn't get chlorination to show up from the mainland. There were delays associated with that. But is that our responsibility? Is it directly tied to our change? That's the analysis we're going through now. So we had a unilateral, then they come with all of these costs, and it's like, wait a minute, just because you can't run a job, we shouldn't have to pay you. So the typical range for that, and this is kind of your inefficiency cost that the contractor builds into a contract, is 25 to 30%. So I know when we do it, we're looking at 20% markup of overhead and profit, but there's also usually when the contractor bids, they have some more contingency or inefficiency. So when we do it as a force account, we're following the provisions in the contract. But if we have to analyze the delay afterwards, what is fair and reasonable? So here is just a little matrix of whether the cost that was added is our responsibility. So if it's a direct result, yes. If it's the contractor's poor planning, labor stacking, resequencing, meaning, and I don't know if Marshall's on, but we just had this with Wahiwa where initially, when you looked at the work that the contractor did under conditions that were not change conditions, they got 2 guys out there with a piece of equipment. If you look at them under their change condition, they have 3 guys managing 5 guys with 10 pieces of equipment. When we document those differences, that becomes the evidence that they are stacking, labor equipment stacking on the change. We don't have to pay for that. Again, it becomes a disagreement, something we have to sort through, but this is why documentation, your diaries are so important. And your basis would be look at what they did when it wasn't a change, and now that it is a change, they're charging us. Okay. If we have acceleration, extended overhead not tied to the specific change, then it's not our responsibility. So that's another analysis that would go with the unilateral. Okay, there's one more change to talk about. And I don't know how many of you, if you guys have experienced this, if anybody has talked about it, but it's called a constructive change. It's basically a change that's implied. So we're not writing it to them, we're talking about it, and they're like, hey, wait a minute, I think this is a change. They also have to put in their notification. So this is caused by the owner's conduct, misdirection, delay, defective specifications. Maybe it's an inspector in the field directing somebody to do work. This is all done without a written change, but the contractor still must provide notification. So here's some examples. Inspector requires tighter tolerances than in the plans, defective specs, plans omit a detail, and the contractor is forced to redesign. These can all be construed as constructive changes. If it is a change, they must provide the notification as laid out in 104. So that doesn't waive their right of notification. They still have to do it. So if they don't orally notify you by noon the next day, if they don't follow up in writing, 30 days later, they come back and say, you know what, when I had to do that plan stuff, that was a change. If they didn't do notification, they didn't follow the process, they have waived their rights under their contract. We don't have to do it. I feel like I'm running out of time, so I'm going to speed. Okay. How can an owner avoid constructive changes? So again, we want everything in writing. You want to follow the contract. We have to train everybody to make sure we're not providing those field directions. If we are, make sure we follow up in writing. Please submit an RFI. This may require a change. So you want to go through a written process. Respond promptly to RFIs and submittals. If you don't, make sure you're providing an extension. Say, I understand what's happening, but give us 15 more days or whatever it is you need to analyze. But it's so important to track that. When did it start? What were the notifications? How long did it take? And if you need extra time, ask for it in writing. Keep clear records. It's all there. Okay, so why is notice important? It provides timely notice to the owner that gives us a chance to investigate, mitigate, or reject the claim. This is super important, and we're going to talk about it a little bit, but if they forego these requirements and impose costs on us, and they've taken away our ability to mitigate the change, it's called prejudice to the owner. And that is another reason we can reject all of this. Okay, so without notice, the contractor can make silent changes and demand payment months later, which is unfair and unmanageable. How many of you have dealt with that? Notice clauses exist to avoid those disputes. Clarity now is cheaper than confusion later. Notification clauses are conditions precedent. So again, these words, condition precedent, meaning that the failure to follow waives the contractor's right to claim. Okay, so this is what I hear. I like to try to say, okay, if you think this is a change, if you feel this is a change, make sure you follow 104, whatever is applicable, and provide those notifications. Otherwise, you're going to waive your rights. So I've heard, I'm not going to read the contract to the contractor. That's fine. But so you don't have to, but you do need to enforce the contract. So if you waive the notice requirement, it becomes harder to enforce next time, or it waives the rights for the entire state, because contractors may say, well, you didn't do it here, you're not doing it here. So it's really important that we all follow that. And maybe you
Okay,
don't want to
that-
remind them, but we do have to follow it. Yes.
I want to jump in. That's actually what has been on the tip of my tongue is the precedent set by DOT across projects. So
Yep.
contractor could FOIA other jobs and say, look, they don't do it anywhere. And so
Right.
how are we
And we're
supposed to
going to
know?
talk about that.
So
We got
to do
a
it across the
million
board.
examples. 50 slides and 1 million examples. So the right to request additional time and compensation is not only contractual right, it's a legal right under Hawaii law. So that's why we spent so much time talking about that. It is conditioned upon compliance with notice and documentation requirements. So we have to follow it. Okay, so I'm going to go through a ton of definitions and some examples. And Cord, you got to kind of let me know when I'm in 10 minutes. I got to fly through this. Okay, so importance of written notification. Don't rely on other forms of notification. And we don't have to. You'll have a contractor say, well, it was in the meeting minutes. That is not notification. Those are meeting minutes. So don't make sure it's a formal notification. Now, I know in email, we're not so much getting memos. We do have the correspondence module in ACC. We are going to talk about that a little more. My preference would be it has to be in the correspondence module or it didn't happen. So, but we haven't mandated that. But again, I want especially construction engineers to kind of think about it, because you guys are the ones that are going to maintain uniformity. Okay, so notice of potential claim, an event that occurred. We're going to talk about, like I said, I prefer to notify the contractor to say, basically, if you don't provide notification, you're going to waive your rights. So you better follow it or you're done, and I'm going to reject it. Prejudice to the owner, promise versus condition. That's what we're going to talk about next. So these are some definition. So what does prejudice to the owner mean? Prejudice occurs when the owner's ability to respond, investigate, mitigate, manage is harmed because the contractor failed to provide timely notification. It's about practical or financial disadvantage caused by the delay of the action of the contractor. And I feel like this happens a lot when they don't give us cost proposals. They start performing the work. We don't know what it's going to cost. And I have an example, so we'll talk about it next. Prejudice occurs when late notice deprives the owner of options they would have had with timely communication, such as rejecting, negotiating, redesigning, investigating, or budgeting. So when the contractor doesn't perform these things, they are putting us in a I don't even know how to say it. Let's just say it's prejudiced. So I'm going to go through an example. And this is my actual example. And we're in the process of settling all of this right now. So the contractor is directed by unilateral change to relocate a water line. Instead of submitting a cost proposal as required by the contractor proceeds with the work, attaches a water line to a bridge or doesn't, designs and orders custom materials, begins installations weeks after. And again, they're proceeding. We have a unilateral. There's a cost in the unilateral. We assume they're performing the work within that cost. They start performing the work, then they submit the cost proposal, and it's 10 times the amount that we have in the unilateral. And it's like, whoa. So which of the following best explains why the owner's positions was prejudiced? I have a hard time saying that word. The contractor did not use standard waterline materials. The owner was prejudiced because they were denied the opportunity to evaluate alternatives or cost control before the work performed. Contractor failed to follow an engineering preferred design. Unilateral change order guarantee the contractor full payment regardless of cost. Which one of those is happening here? Oh my gosh, I don't have letters. Okay. It's actually this one. The owner was prejudiced because we were denied the opportunity to evaluate. I know when I've been pushing on this, it's really because you proceeded and we didn't understand the cost implications of what you're proceeding with, that you have removed my ability to mitigate the change. Maybe I could have worked with Board of Water Supply. Maybe we could have done XYZ, but you didn't give us a cost proposal, and that cost is outrageous, and this is why we would have precedent. Okay, so we're going to go into the next one, which is a promise versus a condition. So again, when we're talking about these things, it could be either a promise, which is a duty that may still allow recovery if there's no harm, or it's a condition, which is a hard stop. If unmet, the contractor loses the right to bring claim. So these are two clauses. Our contract is condition. Our law is condition. So that means hard stop. If unmet, the contractor loses their right. So based on the spec, the notice requirements for change in claims function as a condition, not a promise. Again, hard to say because DOT has not tested this in court, but this is what, again, I haven't gone through court with DOT stuff, and we'll talk a little bit about that. So this is all interpretation, and if anybody on the line has gone through this, please let me know. Okay, so under 107.15, the contractor must submit written notice potential claim. Again, we'll go through, through this series, we are gonna beat this stuff to death. And if you get out of this series and don't you know, kind of have some of this in your head. Like I said, I think a nice little infographic would help. Clearly identify and label it as a claim. There are other requirements under 107. If they don't do that, those are conditions precedent to the claim, we can deny it in totality. They're waiving their rights under the contract. All of that information, again, in 107, we'll take a deeper dive and follow on, must be submitted within 180 days of potential claim or before final acceptance, whichever is earlier. Okay, so we cannot waive these. These are our conditions. If they don't do it, it can be denied in totality. What happens if the contractor needs more time? What if we need more time? Contractor must request an extension in writing. The engineer may approve the extension if justified, but it's at the state's discretion. So again, these are not written. These are almost legal doctrines, and this is the recommendation. If no extension is granted, the deadlines are missed, the contractor may waive their right to additional time or compensation, and it's treated as an acceptance of change. So 104.06.7b basically says if you don't provide notification, then you say that you're okay with it. So our contract is written in our favor. So if they don't do it, it's accepted, we can deny. Again, I don't think we do this because a lot of people waive our rights as the owner. And that's why this is my little notification soapbox. The series is going to be the claim soapbox. And when everybody starts doing it, let's see how the contractors respond. They're going to be pricing things differently. They're going to be doing differently, but it really takes the entire state to make this happen. What happens if we need more time? There's actually no explicit timeline for us imposed under 104, but if we don't respond, then we're giving undue delay, which may give the contractor rights under either constructive acceleration, breach of contract. So they do have recourse. So we can't idly sit by and not do these things. We have to do something. So again, provide the extension if people aren't ready. You understand there's a change. You acknowledge there's a change. They meet the notification requirements, but then they got to follow up with timely proposals. They got to give us their the circumstances. They have to give us details because sometimes we don't understand. Maybe we're talking about cost, and I'll tell you, this is all happening right now. We talk about cost. Oh, we forgot time. Too bad, you waived your rights under the contract. So their recourse right now is going to be, well, this district doesn't do it, this project doesn't do it. That's their defense. And when we all do it, that defense goes away and we can really stand behind our contract because it's a condition of our contract. Okay, the engineer should communicate delays proactively, document reason, It just means we have to perform our obligations under the contract. If we're not doing that, then we're waiving our rights. So the key principles: written requests are required. Verbal conversations, not adequate. And I know this is a lot, and I know not everybody does this, but it's again, a soapbox. Let's get better. Let's get there. Failure to act, we're risking or waiving our right, and extensions are discretionary. So if they don't meet the requirements, we can reject it. I usually on our projects, I'm asking the contractor to request an extension if they're not ready, because we know they're not ready and it's okay. But if it comes to a point where we've been prejudiced, that's the part that's really frustrating. At least for me on my jobs, it's really hard. And then we're going to reject it. Then they'll come back and the rest of the state's not going to do it. And then we're waiving our rights. Anyway, we'll talk more about it through the 9-part series. What is a waiver? So there's an express waiver, an implied waiver, and legal elements of a waiver. Okay, so express waiver clearly states that we're not enforcing a requirement. An implied waiver, and this is kind of more, I feel like, where we are with DOT. A party's behavior shows consistent acceptance of non-compliance. An example, an owner consistently pays for extra work without requiring formal change orders. Later, they try to deny payment for similar work. This may be deemed as a waiver. So consistency on your project, consistency through your district, and consistency through the state. To prove a waiver occurred, courts often look at, is it a known right that the other party failed to enforce? And have they done it repeatedly with clear conduct showing acceptance of noncompliance? And are they relying on the other party? So does the contractor rely on our course of conduct? Does the contractor rely on the fact that we are not enforcing the contract? I'm actually dealing, again, this is all Makaha stuff. Right now, contractor told me, well, we didn't think you were going to impose liquidated damages. So now they're doing a time impact analysis. I'm asking, where's your notification? You can't do this at the end of the job just because we're applying LDs. And now you're saying, oh, well, I had time. You didn't provide notification. Again, not sure how successful we're going to be because that project, we asked for notification. We got notification. We got written extensions. And there are these little things that they're realizing they didn't do, and now they're asking for compensation. You know, the first line of defense is to deny. So we'll see how it goes. Contractor gives late notice and the owner accepts it without objection multiple times. Did we waive it? Yes, the owner may have waived the notice deadline. The owner ignored the lack of reports and demands strict compliance mid-project. So they did it. They didn't do it at the beginning. Now they're doing it. Maybe because it depends on consistency and the impact of that consistency. And if the owner explicitly says, we'll accept this once, but not again, not a waiver if clearly limited. So I don't know, my Cal Highway people, we're dealing with a claim right now. And the discussion is, okay, if we want to entertain this, why are we entertaining it? So in the letter, we said we're entertaining this, and the justification was because the top leadership of the project had left the project. And so maybe there was not, you know, Albert retired, Ryan retired, there was a rash of retirements, but even on their side. So the reason we accepted it and the reason we went through the process and the reason we entertained it without some of these requirements was limited. We provided a reason in our documentation, and we said we're only doing this because of XYZ. If we can do that and we limit it and we provide justification and we are entertaining it, then we're not waiving our rights. If we do it consistently without writing down why we're waiving our rights. So the issue is inconsistent enforcement across the islands or offices. Under the statute, strict compliance is generally required, but repeat conduct might still create an implied waiver argument on the contractor side. So I feel like for us, this is our biggest risk. So one field office strictly enforces 30-day notification. Others routinely accept late claims. This might be an applied waiver. Different islands follow different review and documentation process. This opens the door to claims of unequal treatment and contract ambiguity. So this is when we're not going to be able to do it. This is the entire reason that it's difficult to enforce notification, and we have an implied waiver. Inconsistent application of spec section, force account, submittal deadlines, RFIs. Contractors may exploit precedent set elsewhere to justify non-compliance. So I don't know if Brent's on. I know there was an issue with Oahu District probably 5 years ago. Contractor was paid for these reasons because there was implied waiver. So, you know, under econ, under these things, if the construction engineers really want to make an effort to make sure things are consistent, maybe there's a way we can document the consistency and provide that as our justification and really start enforcing the requirements of the contract. And we can do that. We can make an argument that it's not waived if we waived it. Let's say we waived it yesterday, but we're putting these procedures in place, and in October we're not waiving it. That's within our rights and that's within the contract, as long as everybody does it consistently. Estoppel, I just learned this because I didn't know what this is. Estoppel is a legal principle that prevents someone from contradicting their prior actions statements and legal positions. In essence, it stops a party from asserting a claim or right that is inconsistent with previous conduct or representation. This doctrine is rooted in fairness and aims to prevent injustice by holding individuals to their earlier commitments, whether explicit or implied. So I'm running out of time. I'm going to let you read these things. Basically, our specs have an anti-waiver clause in it, which means that we could stand on that, especially in isolated incidents. No oral or statement or conduct shall deem a waiver of written requirements. So we can stand on that, but consistency across even your project, your district, your state, if we can show that our spec allow for that there's anti-waiver, that they can't say there's an implied waiver, but again, precedent and consistency is the key to winning in court, let's say. The clause is designed to block claims of implied waiver by making clear that the only written modification or waivers count. If it gives DOT stronger legal footing to enforce deadlines, even if they were lenient in the past. So again, this is potentially a separate discussion. You know, construction engineers got to let us know how they want to proceed, because again, there's that obligation to make sure that we're consistently following this. Okay, so untimely protest of unilateral change. What happened? DOT issued a unilateral change order. Contractor performs the work but doesn't submit a protest or a notification of claim within 30 days. Under the requirement, this constitutes acceptance of the terms and their claim is waived. So again, when we talked at the very beginning, if they proceed with work and they don't follow the process, in 104.06.7b, they have accepted the terms. So I know that that's something I don't usually do, but after studying all this, I'm going to. So this is another example. Failure to provide force account records. What happened? The contractor performs extra work. It doesn't provide daily costs within 10 days. Even if the work was done, lack of documentation as required means a waiver of entitlement to compensation. We can talk more about that. I'm not quite sure, but again, if they're not following it, we could do a unilateral, we can pay them, and they start to waive their rights under the contract. So timeliness is key. Again, written, if they want an extension, they have to do it in writing, so we preserve our rights under the contract. The owner accepts late notices regularly. So what happened over several months? DOT accepts multiple late claims without objection. Contractor submits another late claim expecting the same treatment. The legal risk, the state may be found to have implied waived strict enforcement because of its prior conduct, unless protected by an anti-waiver clause, or we've done all this in writing, that we allowed extensions, we said it's okay, you don't have, you know, I know you didn't do this, but because of XYZ, I'm going to allow it in this case. So we're limiting that action. Again, small examples, further discussion. We have a 9-part series to really bang out what we're doing in this case. So the takeaway, under 104, waiver is automatic for missed notes. So this contract is waiving, that contractor waives their rights. It's automatic if they miss notification deadlines, unless the state has clearly and repeatedly allowed exceptions and the anti-waiver clause doesn't apply, because we are now waiving our rights. Enforcing consistency is key to preventing unintended waiver. So what are we going to do about it?
What if you in the past did that, but
Mhm.
then on this project you made clear up front that notifications are, we might have done this in the past, but for this one, does that waive that
As
past
long as
behavior?
so everything falls back into what is that? Golden rule, right? Am I being fair? Am I trying to be fair? Are they trying to be fair? So as long as you've said that, and that's why I said, if we all as a group say, okay, right now we're going to enforce it, contractors are going to freak out because they're not used to it. And I'll let you know what happens with Makaha, because I can't believe a contractor put in writing, we didn't think you were going to charge LDs, so now we're working on our time impact analysis. Like, okay, I mean, it's our right under the contract, and that's another liquidated damages. So I believe there's a way to move forward consistently. Now, will they have a case if people are waiving their right on Oahu? I don't know. And that, I think that was one of the issues on the Oahu case. You had a contractor that's doing work on Kauai, it's doing work on Big Island, and they're getting different treatment. That is when we will have an implied waiver. So it is super important for people. If we say now moving forward, we're going to do it, it's our right under the contract. We deal with them kind of raising a fuss, but we act in good faith and we give them an opportunity and we scale up. Like in my mind, when I was going through this, I'm like, okay, if the beginning, say January 26th, and we tell them this is going to be required, it's in the contract, we may have waived it in the past, we're not going to, and we all do it as of January, I think we have legal precedent. I think we'll win. Again, untested, and I got 5 minutes to fly through the rest, but
Yeah.
I
No, 'cause
believe as long as moving forward, we do it consistently, I believe that we would not be waiving our right.
I know, in the pre-con meeting
Yes,
agenda, we go over that and we read it
Yes.
verbatim, but
yes.
I don't know if that's
So right
strong
here,
enough, right?
yeah, we
Like,
don't know until we test it.
Yeah.
And we don't test it. And I don't know if I'm gonna get through everything, but so what do? We have to standardize the expectations, ideally statewide. Ensure all field offices are trained with exact notification deadlines, documentation protocols, and claims. So again, this might be an ongoing discussion with the construction engineers, how you want to do it. We put out information, your REs and everybody are checking for these things. And we, in my mind, we kind of gear up to let them know we are no longer waiving our right. This is a statewide effort, blah, blah, blah. We require written approvals and exception. So again, if we know, and we did this on Makaha, was like, okay, we haven't gotten there. Let's give us another 4 months. We put it in writing. They requested, we approved, we weren't waiving our rights. We need to communicate with the contractors, maybe tell them at GCA, do a presentation like, look, we've done these things in the past. We acknowledge that. As of January 1, we're not doing it anymore. So make sure all your contractors know. If we take these steps and act in good faith, I think it'd be very hard for a contractor to come back. And then the last one is reinforce that the past tendencies or leniency does not waive future enforcement, and back that up with written reminders. So I think there's a way we can get there. Now, the general
If we send
principle.
monthly reminders, real
We could
quick
do
on
that.
on a project,
Mhm.
even before the culture changes, if you send monthly documented reminders to the contractor,
Mhm.
that sets a precedence even for that job alone.
Right. Then we can come up with a plan. And again, this is to your point, Randall, that make it clear during pre-con meetings that the state is enforcing based on the contract. I think we read it and we don't do it. And I think it's a collective effort to have this reinforcement. And so trying to look at case law, what general principle from Hawaii courts, while not specific to DOT, Hawaii courts have recognized that failure to comply with the clear contract notice provisions can bar recovery. So, we could do more research on this. This was very, quick research, but where a contract explicitly requires timely notice, because the state law and the contract requires this. So it'd be really hard for a contractor to say, I didn't know. If we're telling them and it's written and we remind them, state law says this and our contract says this, you better do it, you better do it, you better do it, and they don't do it, I think we have a solid case. There's another case, a dispute over, actually, this was 2013. I kind of wanted to see what this was, but dispute over compensation under city and county construction. The court emphasized contractor duty to comply strictly with the contractor claim requirements, including timelines. So it might be sparse because most DOT contract disputes are resolved via administrative resolution. So again, under 107, the procurement officer can make those kind of decisions. So we may not see legal precedent because we don't go to court. We usually settle. So Why are we settling? Is it justified? Are we setting precedent? I think those were all in it. So I know Kaha'a had a desire to kind of look at this statewide. So if we can look at this statewide and really analyze our precedent, what we're saying, are we waiving our rights, and really kind of gear up, let's say, I think we have a good chance. This was a little poll question, but I don't know if anybody on the line has gone to court or mediation for a claim. Mediation is not a recourse under our contract, but I know at Hart we had a lot of that. So that's kind of notifications. I'm gonna fly through some other things. So if you have to go, I get it. This is a lot of content, but I wanted, and there's a reference, right? So I got, what is that, 12 more slides. These are random definitions that we're gonna explore through this series. So I wanted to introduce it. So doctrine, what is doctrine? I don't know if Daryl's on, but in one of the projects we're dealing with, there's the doctrine of economic waste, and there are a ton of those doctrines. So this series will go through doctrine. So what is that? It's just a legal principle or rule. It guides how the courts interpret things. The doctrine is not written in contracts, but it can influence outcomes. It fills the gaps where contracts are silent, maybe law is silent. And overall, it's a common sense fairness. So if you think about it, you think golden rule. Is this fair? Did they act fairly? Did we act fairly? That's the overall analysis. So just think, oh, I repeated it. Common sense, that's how the courts are going to look at it. Is it fair and reasonable? Now, this is one I thought was interesting to kind of put in your minds a little bit. Patent defect, because there's a latent defect and a patent defect. Patent defect is an obvious error or flaw in the plan's spec. So again, this is to Andy, who's on here from design. I don't know who else is design. These are also doctrines that come into play. So we talk about notification, but if we have an issue with our plans, is it a patent defect of our plans? We start introducing all these other things. So that's where the analysis of the overall issue becomes important. So implication is if a defect is patent or it's obvious. So I know on Kauai we have this rumble strip issue. I'm not super, but this is what I was thinking of when I thought of patent. Was it obvious? Because a contractor, if they don't raise it during bid and the contractor comes back, they cannot recover costs. And this is also in your contract. They don't raise it during bid and it's obvious, they can't cash in during construction. So we can deny it because if it's a patent defect, it's an obvious defect, you didn't bring it up during bidding, you accept that condition. They have waived their right. They have accepted the condition. So how do we prove a patent defect? You must show that the defect was obvious or reasonably discovered by the contractor at the time of bidding or during construction. Unlike latent defects, which I don't even know what that would be in this scenario, we might come up, but a latent defect is more, it was hidden. So was it obvious? Were there apparent defects? Was it something easily found? That's the test that we would have to go through. So again, patent defect, like something you don't really see, or no, that you do see, you're in a house, you see a crack, that's a patent defect. Latent defect is the foundation is sinking, you can't really see it. So one is hidden, the other one's obvious. Under the patent defect, there is a duty to report. And I know this is in our contract. Again, through this series, we'll talk about it. Okay, so this is another one. What if the contractor lies about their costs and it's overinflated? Is that okay? No. It's not okay for the contractor to lie about or knowingly inflate their costs. This is kind of why I would love to do an audit, because if we don't agree, we feel that it's inflated, we could audit the contractor and we would win. Why would we win? Because it's a breach of contract. Most public contract, including DOT, requires the contractor to certify, and this is why the certification that is in 107 is important and also cannot be waived. A lot of times they will submit there's a very specific statement that they have to put on their claims. If they don't put it, deny. They have to be truthful, they have to be accurate, they have to be based on actually incurred cost and reasonably estimated cost. Lying, exaggerating cost violates the duty of good faith and fair dealing and gives the owner grounds to reject the claim, withhold payment, or terminate the contract. Where does it say this, you ask? Oh my gosh, here it is. False Claims Act. I love the False Claims Act. They can't lie to us. Can't lie to us. I had one contractor told me it's my job to lie to you. I said, actually, if it is, you're in breach of contract as well as state law, because both laws, again, if it's federally funded through a 1273, there's a provision that False Claims Act, and then you have the mini False Claims Act, which is the state act. Penalties can include is that supposed to be treble? I think it's supposed to be triple damages, civil fines, debarment from public contract, or criminal charges. So again, contractor can't lie. If they lie, we can do an audit. We can find out that they lied. So not only can we deny their claim, but we could actually seek damages under False Claims Act. Okay, this is all fun and exciting stuff. Audits and investigation. DOT and Federal Highway may audit contractor records to verify costs. If it's inflated, we deny the claim, we demand repayment, we go to the AG's office. Knowingly overstating costs is a serious offense. Not only is it unethical, it can lead to contract denial. I'm sure they could be blacklisted. Well, I'm not sure, but we'll see. Owners must diligently review, audit, and document claims. Okay. Prohibited conduct. So again, I wanted to make sure. I was talking to Daryl the other day and he's like, if it's not written, I don't know. So I wanted to provide that. This is the False Claims Act, the state law. So that applies to every contract you guys do. Public agency, when they knowingly present or cause to present to an officer or employee of the state false or fraudulent claim for payment. This includes claiming cost for a change. Just because it's a change doesn't mean you can ask for whatever you want. It has to be an actual cost. Now, what those actual costs are, that becomes the burden of the analysis. Okay, so how do owners protect themselves? Require detailed breakdowns. Again, the contract says whatever the engineer wants, contractor shall give you. So if you need a breakdown, if you want to see other costs, they can't deny it. And if they do deny it, then you can deny their claim that they're not reasonable. Again, providing that review, including the certification language. That's why we have to put those certifications on the bottom of our documents, because if it's found that they're lying later, then we can, go after them under false claims or actually recover damages. What is a damage? So again, through the series, we'll talk more about this. These are the various direct damages. Kind of ran out of steam when I got to this, but we're going to talk about what these costs are and what people can seek as in the future. And then sufficiency of proof for damages. A claimant need not prove his damages with absolute certainty, which means it doesn't have to be, receipt. As long as it's mathematically exact. So not an estimate so much or a swag, but something that's reasonable. This is sufficient if it's furnished in course with a reasonable basis. So again, our analysis, the CE's analysis, is it reasonable? Does it make sense? Those are really those tenets. This leniency is actual mechanics of computation, does not relieve the contractor of his essential burden of establishing facts, liability, causation, results, yada, yada. Okay, so a lot of information. I know I went over, but I wanted to throw those things out there to kind of build up our follow-on sessions. Do you guys have any questions? From this day forward, document only exists if document. Yes, document. I think, I didn't do a wrap-up slide, but because it's a series, we'll talk about it. I hope I got the juices flowing for people. Notification, let's not have an implied waiver. I think that's our biggest risk right now. But we can, as a state, come up with a plan to make sure that we don't do that in the future. We can change our behavior and really start enforcing our rights under the contract. So that's all I got. Any questions? I don't see any questions. I'll hang out for a minute if people want to chat about it. I do have time. Sorry, went over. Yes, Andrew.
For a unilateral change, is there a cost estimate or a not to exceed
Yes.
amount such
Yes.
that if the contractor doesn't submit a claim within 30 days, he still could get some compensation or not?
Yes. Yes. When we do unilateral, our process requires justification of cost. So we would base it on our estimate. And that would be either, lump sum, like you said, we could create a force account, you could do unit price, any of those things. Yes, there's a cost component. Our backup would be this substantiate our cost. And that scenario, that's why I kind of like it, that if the only way they can really claim is they come back with their actual cost. And right now, what we're dealing with is their actual cost in some cases are just ridiculous. So how do we then analyze that? I think on our project, we allowed for two things and we were denying another one. Contractors coming back trying to seek compensation. I believe we will still deny it, but when we look at it as a whole, I think we allowed for these costs, we made these payments, notification was not, this is the part we're grumbling about right now, because again, it seemed like they waived their notification, and on Makaha, we were really diligent with, if we didn't sell it, and Danilo's on, he helped with that. I think Gord helped with it too. If they didn't settle, if they didn't do it, we were doing written extension. So the fact that I think November of 24, they came up with, oh, by the way, here's all these costs. It's like, whoa, I thought we were dealing with two things. We were very diligent about dealing with the two things. And now you're saying there's this other thing. And then again, this is stacking everything at the end. Now that we're talking, okay, and this is what your LD amount is going to be. Oh, wait a minute. We didn't know you were going to charge LDs. Here's some more costs. So I believe in the end, we will be denying it at the project level. It'll get elevated, I'm assuming, through the district. And all of these things, I think, I know I've been thinking about Kaha'a's, statewide claim stuff, especially as we're going through this series. And I think that not only for just a general awareness, but I think that will help the construction engineers know what's going on so that they all play in the same realm. That if it's, okay, you let it go there, and especially with the same contractors, we have a lot of the same contractors dealing with a lot of us across the state. Consistency is key. Documentation is key. Need a follow-up on notifications, how to address or not. Okay, I'm not sure what that means, Calvin, but yeah, definitely reach out. We can talk about it.
As part of my, I guess it'd be an audit, but more of a tracking of
Yeah.
what claims are going on across the island. One of the pieces of information I want to know is the notification component. So that'll be part
Yeah.
of the information we collect.
Well, and that's why, to Calvin's point, as I've thought about this stuff, it does make sense to have some kind of form in ACC, and that we almost codify or make it consistent, because then we can do dashboards from it. So as a general knowledge sharing for those on the line, that when we create forms in ACC, that's why it's important to use the forms that we've created, that we can take those fields and create dashboards. And as long as everybody across the state is doing it, then we can download and gather and track that data. So that's one of the reasons we're doing more of these forms. We were working with Headlight on a change order. I don't know if Eddie's on, but we are talking about putting more of those forms, I believe, in ACC for those reasons, so that we can see what the necessities are. We can look at the cost estimates and how people are doing that, really as a measure for consistency across the state, because then through that consistency, we can enforce the provisions of the contract. Again, on this particular claim, I think somebody was like, oh, the contractor was saying, well, how are we supposed to know that? I go, I get it, but the contract requires you, it's written in our favor. Contract requires you as a contractor to be pretty much perfect. So yeah, I get it. It's tough, but you signed this document. You said you were going to do all these things in writing. So now that you're not doing it, that's not really my problem. It's your problem. So,
On that note, Kai, even in contract law training where I came from, contracts are written in our favor.
yes,
He should abide by everything written. But on the flip side, it is on the incumbent upon the government to uphold the components that you're training on today, the documentation, the notification.
Yeah.
We are essentially we do, what is it, the burden of, we
Proof.
do carry a burden, but as long as we
Yeah.
document and do our job, it is on the it is written in our favor.
Yep. Yeah. So, when I was thinking about this, I was like, oh, what a glorious day it would be if we could just deny everything, because it's just so frustrating. And I think there were words in there I didn't get to expand as much because there was so much material, but it is frustrating when they come back. We think we're almost done. All right, we got 2 issues. Oh, now I have a TIA, and now I have this. Now it's like deny, deny, deny. You can't do it at the end of the job. And part of it is they're looking at their books, they're realizing that maybe they didn't make as much money as they should have. And now how am I going to recoup that? Well, it's not my job to make you whole. If you had followed the contract and done this through the contract, then there's no prejudice. And I think that's the frustrating part, because you took away my right to mitigate. Maybe I could have eliminated that work. Maybe I could have reduced it. Maybe there could have been a better way to approach it. But because you proceeded and I didn't know it was going to cost this much, or in some cases, I think even with the concrete, granted, I'm not as involved day to day, but this concrete thing they're claiming, I didn't know it was extra money until you flopped this packet on my desk a year after the work. Like how I could have said, don't do as, cut the channel. Like don't line it. I don't know if I could have done that, but you eliminated my ability to mitigate it because you didn't tell me that it was going to cost this. So does that require me to pay you now? It's not fair. I mean, so it goes back to the fairness. You've taken my ability to do, maybe I could have just taken that out of scope and had some other maintenance contractor do it. Because I think the concrete, and obviously Ben and Danilo know more, but I think it was part of the channel lining that was required. And so it's, oh, well, it had to happen because it was design. I don't know that. It's too late for me to investigate it because it's already done, but I didn't know it was going to cost 6 times what we put in our unilateral change. That's why I kind of feel like we're on solid ground, because we gave them a unilateral change. Their notification, this is where I got to review everything, but when I reviewed their initial notification, they did not tell us about this concrete. It was not in the thing. Granted, I know Danilo did a great job at analyzing things and looking at it, but I'm harping on notification because we were so diligent with the notification throughout the contract. And I really feel like now they lost money and they're trying to figure out how to recoup it. And in my mind, it's too late. But again, we're at the project level. We'll elevate it. We'll see what happens. But this is one I probably, I know even the Cal Highway one, I don't know if PAC is on, but some of these contracts, we do a great job at documenting it. And it's very, I guess I don't know if it's on here, but it was part of it is, what happens when one team is not following this. It really disheartens the rest. Those people that are working to try to do a good job to make sure it's documented, harping on the contractor, and then other people are kind of waiving our rights under the contract. So that's why I had my little soapbox moment. Any other questions? So again, I know this is exciting stuff. 1 in 9, I have to work with Cord. I don't know when our next one is, but there's a lot of content here. So hopefully it just stirs you a little bit. And as a construction engineers, let this sink in. I think it's that implied waiver that's our biggest risk as a state. So thank you guys. I'll hang out. But you guys can leave anytime.
Thanks, Kai.
Yep.